Today we're going to go over Chapter 16. We're going to talk about copyright and the First Amendment and libel, and I'm going to show you some new trends with copyright issues. So copyright was the second law to be passed in the United States when Congress first convened in 1790. And copyright protects ownership rights of creative works. The law was created to motivate people to be creative, to enrich society, and allow people to earn money from their work. Creative work is known as intellectual property, and so that is what copyright covers. The creators of intellectual property grant permissions for the use of their work, and they charge a fee usually. So sometimes media companies come in and they'll offer attractive boosts in sales through their wide reach and all of their resources so that an artist will assign the rights to their intellectual property to a larger entity that pushes it out to the public and gives the creator a fee or a percentage of the sales of their revenue. So this is very common in today's world with like record companies, movie companies. Everywhere you look, there are large companies promoting creative works for profit, and then the artist gets paid. So copyright is an old and important law that protects your creativity and allows you to turn a profit from your ideas. Some alternatives have been popping up on the internet to encourage sharing among the creative community, because some people feel that sharing their works is beneficial to the world, or they just enjoy it and they want to define the limits and the stipulations that are placed on their own work. And many times they just want to receive credit for the work that they have done. So one emerging system for giving creators more control over their intellectual property is Creative Commons. And Creative Commons provides a variety of different types of licenses that can be attributed to creative works, including music, photographs, literature. So I'm going to play this short video, and then I will show you the site and the licenses, the different types of licenses.
What does it mean to be human if we don't have a shared culture? And what does a shared culture mean if you can't share it?
It's only in the last 100 or 150 years or so that we've started tightly restricting how that culture gets used.
The internet enabled an infrastructure where anybody could participate without asking permission.
We have all these new technologies that allow people to express themselves, take control of their own creative impulses, but the law is getting in the way.
Creative Commons is designed to save the world from failed sharing. People who actually want to share stuff, who put it up on the web because they want to share it on certain terms.
So we wanted to create a simple way for creators to say to the world, here's the freedom that I want to run with my creative work. Here are the things you're allowed to do.
Can I reproduce it? Can I copy it? Can I put it in my textbook? Can I use that photograph? Can I make a new version of it?
Creative Commons gives tools to creators to make a choice about copyright.
Creative Commons license can cover anything that copyright covers.
Every license says, you need to give me attribution. I created this, give me credit for the work I did.
The basic choices are commercial use or not. Can you make derivative works, versions, adaptations, or not? And do you want me to have to share alike? So if I take your stuff, do I have to offer it to the next person under the same terms?
There's no requirement for you to do anything with your work other than what you want to do. You own the copyright to it. What we've done is given you the right to exercise your copyright in more ways, more simply.
So the idea here is to enable that creative impulses that the technology turns loose and get the law out of the way.
The work of Creative Commons is really about laying the infrastructure groundwork for this new type of culture, a new kind of folk culture.
Somebody from Delhi, somebody from New York, somebody from Singapore
can feel comfortable using a photo that was created and given away by someone in the United States or in China or wherever that the licenses have been extended to,
with their identity being preserved.
Which means that people can actually create new kinds of things, come together and build things.
Mashups that people can do with people's Flickr photos.
And CC Mixter has allowed artists to make music together.
It's really about creativity and connection.
Access and control.
From amateurs who simply for the love of what they're doing and they want to share it and they want other people to be able to make use of it, to commercial organizations.
In the end,
this will have a very successful place in the for-profit economy.
Creative Commons is the bridge to this future. Is you got to move away from thinking about content to thinking about communities. Communities that develop around content, and the sharing that the licenses allow enable these communities to come together.
A physical commons is like a part where anybody can enter equally. A commons with intellectual works is actually much freer.
It really is going to be the pillar for communications between people, cultural exchange.
A space for more speech, more free expression.
And that's the kind of commons we're trying to create.
Okay, so that was Creative Commons, and now I'm going to show you some of the different types of licenses that they offer. So there's these different layers of licenses. You can do an attribution, and this just lets other people distribute and remix and change your work, even make money off of it as long as they give you credit for the creation. And then they have attribution, no derivatives, and this allows people to redistribute commercially, make money, and non-commercially as long as it's not changed and you're credited. And then you have attribution, non-commercial, share alike, and this lets people change your stuff, build on it, but not make money off of it, and they have to give you credit. And then attribution, share alike, this lets people change it, build on your work, even make money off of it as long as they give you credit and as long as they let other people share their work and do the same as you did. And then attribution, non-commercial, this is you can change it and do lots of stuff with it, but you can't make money off of it. And then non-commercial, no derivatives. This is the most restrictive, and it allows you to download other people's work and share them with other people as long as you give them credit, but you can't change them in any way and you cannot make money off of them. And so these licenses are free. So when you create a photograph or anything like that, you can go here and put a license on it so that it is copyrighted to you. So I just wanted to share that with you guys. And then I wanted to show you some sites that have really helped me as a designer through the years. Morgue File is basically a stock photo site where people upload pictures that they've taken that they want to let other people use. And then there's different ways that you can use them on here too, and some people want you to give them credit and some people just upload them and you can use them as you wish. But these are royalty-free pictures, so I can type in something like, let's say, Christmas, and it will give me a whole bunch of photos of Christmas that I can pull from to use in design work or whatever I'm working on, which is really helpful sometimes. And then it's also linked into Dreamstime, and this is kind of the same, but these ones you have to pay for. So you can go in here and you can download a 72 DPI for different credits. They have different pricing on all of them. So those are that's another really helpful site that I found during my time designing. And then I also wanted to show you Brands of the World, because this has saved my life more than once. A lot of times you end up making posters that require logos of big companies, and you have really bad images of those logos. If you come to Brands of the World, these are, they are trademarked, but if you need to use them or it's okay for you to use them, you can come in here and type in Coca-Cola, whatever it is, and then it gives you a choice of all of these different logos, and they are already in vector. You can download vectors of them and manipulate them and do what you need to do with them. And it's just been a huge help for me as a designer, so I just wanted to share that with you. brandsoftheworld.com. Consumer rights and the idea of copyright have collided in recent years because people can gain access to intellectual property so easily with the internet. So one of the first train wrecks that we witnessed in consumer rights versus copyright issue was peer-to-peer sharing sites like Napster and Grokster. Files were charged for copyright infringement against these companies because the site's users were sharing music and films online. And both Napster and Grokster argued that their sites and their software were neutral and that misuses of the software should be pinned on the users sharing the copyrighted materials on them. Grokster lost the case because the court cited that they had advertised this type of file sharing as the main use for the software, and their advertising had promoted users to break the law. So the lesson was that peer-to-peer devices were accepted if the company did not encourage breaking copyright law. And that's why YouTube has stayed in business. They do a certain amount of work to protect the copyright laws, and they state that you will be held accountable for your infringements on it if you break them. So because of the popularity of peer-to-peer sharing, new sites pop up often, and old sites like Napster have actually survived with a new label, and they discourage copyright infringement. A few years ago, several hundred college students were sued as an example of the law, and they were charged with infringement for sharing movies and music. They had to pay settlements to the different companies for their actions. And then there was the case with the Google Print Library, which was a project to digitize 15 million English language books for online index access by Google. The company had talked 5 libraries into digitizing their collections, and they wanted people to have worldwide free access to the literature. And Google got sued by the Association of American Publishers and settled with them in 2009. And the group felt that Google's actions had really infringed on copyright law of the authors, and they were correct, according to the court in 2009. There's also another site that popped up called the Gutenberg Project, which is an amazing, amazing site. And what they've done is they've digitized works of literature that have their copyright has ended. There's no copyright left on them anymore, and they are part of the public sphere of ownership. And so you can go on there and download books that the copyright law has run out on to your Kindle for free or for a really low charge. So that's kind of a fabulous project you should check out if you get a chance. While the government has been forbidden to impede free expression through the First Amendment and the part which pertains most to mass media, the free expression provision, there are exceptions like national security, and we can't just say whatever we want or be slanderous. Prior restraint is a prohibition of expression in advance, and it's the most heavy-handed type of government infringement on freedom of expression. So this refers to suppressing a publication because of what they might say next. And this was deemed unconstitutional in the Neer versus Minnesota case. And prior restraint was banned. But even though it was banned, there are still special circumstances where it could be admissible, which include life and death, or extreme situations and wartime. So because prior restraint is banned, a person cannot be censored before they publish. But if they break a libel law, etc., then they can be prosecuted. So there has to be more than an intent to do so. Under our First Amendment, even advocating lawlessness is protected. It is protected up to the moment that the lawlessness is incited, and authorities can only silence someone in this case if it falls within the guidelines of the incitement standard, which is that the statement advocates a lawless action. The statement aims at producing lawless action. Such lawless action is imminent, and such lawless action is likely to occur. But unless these 4 really super hard to prove points are hit, a person's speech is free to say whatever, even if it's against the law. National security is a touchy point when it comes to freedoms of speech and publication. It's one of the strongest stances the government can take on censorship. And when the government went after the New York Times in 1972 over the classified defense documents called the Pentagon Papers, the courts ruled in favor of the Times, citing that the people's right to know about the government's defense policy was more important than the government's claim that the Times was jeopardizing national security. So even in cases where the government pulls the national security card to suppress something, it is ultimately up to the courts to decide if the claim is appropriate. Public endangerment is another tactic that's used to suppress speech. Public endangerment is usually seen as inciting violence, like walking into a crowded theater and yelling fire, and inciting a panic or pain and violence on the general public. So out of this justification emerged the fighting words doctrine, which sees preventing a riot as a justifiable reason for preventing speech. The law views public safety as more important than free expression. Another limit which has public safety in mind is the TPM standard, like putting limits on media that impedes traffic, the flow of traffic, like walking or driving, or placement of media objects in ways that are dangerous. You can't place them in ways that are dangerous or going to hurt people. So this law requires that the regulations on the media are content neutral and that the motivation behind them is to maintain safety. This is seen a lot with the billboards. There's a controversy going on with the billboards that have the video screen, the DAC boards. So they're showing commercials and they have to adhere to certain standards that don't distract drivers and cause accidents. Over time, the First Amendment protections have been broadened. Political expression was the basis for the First Amendment, and these rights were gradually afforded to commercial speech, which was seen as less important than political discourse. So the rest of the media were not always included in the idea of free speech. Emotive speech is also protected, and this is when vulgarity or obscenities underscore the intensity of an emotion, also known as inexpressible emotions. There's an interesting quote which expresses the idea of emotive speech. Justice Harlan said, "One man's vulgarity is another man's lyric. Words are often chosen as much for their emotive as their cognitive force." So sometimes we need to use obscenities and swear words and emotion, or to express an emotion. But the court does take a politically correct stance on hate speech, which is offensive expressions towards others based on their race, ethnicity, or sexual orientation. So attacking someone based on these components is a punishable crime. Libel is a written defamation. It's a provision that protects people from saying anything they want about anybody they want. It's usually a slanderous or hurtful statement that affects the person who is indicated in the statement. Libel protects most private citizens and does not apply to public officials or others who have willingly put themselves in the public stage. In order to prove libel of a public figure, today you have to prove that the author of the icky statement showed a reckless disregard for the truth, and it's difficult point to prove because you have to show that the author knowingly and willingly printed lies that were a defamation to you. But for the most part, anything can be said about people who choose to be in the public eye. Under this idea, comment and criticism is protected. So the fair comment, a criticism doctrine states that any public performance can be commented on in negative or positive ways without worry for the critic of being sued for libel. So you can criticize things that are out in the public. New ways have been found to go after media that makes disparaging remarks that are not covered by libel. Trespass has been used more and more to accuse a reporter of trespassing on private property in order to get information. Another route that has been taken to fight back against negative reports is charging the reporter or the company with fraud, and this is often done in a case of investigative reporters who pretend to be someone else in order to gain access to certain places that a reporter would not be gained access to. The Patriot Act was born after 9/11 during the Bush administration. Too much controversy and condemnation. This law seemed to infringe heavily on the First Amendment in the name of national security. One of the most disturbing and controversial portions of the law was Section 215, which allowed the FBI to search libraries and bookstore records for customers' purchases and rentals. And this was said to be helpful in searching for terrorists by tracking their reading lists. Libraries and bookstores felt that this was an extremely oppressive action by the government, and they rallied against the provision. And the ACLU went after this heavily, trying to prove that it was unconstitutional, but then they dropped the suit after the provision was changed a little bit. And I have an article that we'll go over in class about 215 and the issues dealing with the Patriot Act. So that's all I have for you on media law today. I will see you in class. Thanks.